What if your ex empties your bank account before anybody files for divorce? Well, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. You know, we all know that if there's a court order during a divorce that says that the parties are not to touch any of the money's frozen, then clearly if somebody violates the order, there's going to be hell to pay. Now, if there's an order freezing assets, the bank is aware they're probably not going to let you take the money anyway. But what about if there is no order? What about if two people are fighting and they're married and there is no particular order one way or another because there's no divorce pending? Can one person go to the bank, clear out the money? Short answer is if they're on the account, yes, they can. You may be at risk for that, for your spouse going into the bank. You're on the account, they're on the account. As far as the bank is concerned, both parties own all that asset. Either one of them can take it out and bring it to $1 or bring it to zero, close the account. What are you going to do about it if that happens? Well, if that happens and you file for divorce immediately and ask the court to order the parties to reinstate whatever money was taken, you order the parties to replenish it, you may be lucky. You may be lucky because if you do it that quick, maybe the other party hasn't spent it yet. But as I have told many clients in the past, two people have a fight. Somebody goes in and clears out the bank account, and then that night somebody goes and blows it at the casino. And now the account is empty. You know what? There's no court order that says that somebody can't blow the money. There's no crime in blowing the money. And you can complain all you want that, half that money was mine. But the longer you wait to file for divorce, the more the court is not likely to be receptive to that argument. Now, if you argue to the court that this was done on purpose, this was done knowing full well that a divorce is coming, they did this just for spite, they spent all their money, they spent all my money, the court might, in that circumstances, say, look, this was well known to be in contemplation of a divorce. This was designed to invade the other parties, the share of the other party's, marital asset, and therefore we're going to order it reinstated. If they don't have the money, we're going to take it out of another asset belonging to the spender. The court could do that, but again, you have to remember, the court's going to look at the overall picture. You wait 6 months and decide to raise that argument, don't be surprised if the court says, I'm sorry, you should have told us before, now there's nothing we can do about it. So obviously timing is crucial in that situation. If you have a question about your case, reach out, of course, let us know. We'll be glad to help you out.